Then we also had the Torrey Canyon. That was an oil spill incident, and there were like lots and lots of tons of crude oil that was spilled in the sea, and wildlife, that is seabirds, were killed. Almost over 15,000 were killed. And another occurrence was that this is a pretty recent one. There was the MV Wakashio, that is a Japanese bulk carrier that ran aground on a coral reef. That is on 25th July 2020. And in this case, the ship leaked fuel, a little bit of fuel, and it broke apart. So it's okay. At first, it leaked a little bit of fuel. Then later on, when it broke apart, there was so much fuel spilled on the corals, and it was such a big deal. Then there's also that other incident that occurred a while back, I think 1987, the Doña Paz, where it was a collision between the Doña Paz, which was a ferry, and it collided with an oil tanker, the Vector. And the result was lots of death. The total hit actually over 4,386 people who died in the course of that accident. Another one is the Amoko Cadiz. I'm sure you've been introduced to it. And so there are many incidents that actually occur out there at sea. And the nature of the sea transport is that it is not like the roads where it is very accessible, and a vessel that is engaged in an accident can just be brought to shore that easily. Sometimes maybe it's in the high seas out there and an incident occurs. What happens? It means there's need for regulations and arrangements in place that allow for such rescue of maybe vessels, rescue of persons aboard the vessels, rescue of cargo and all that from such vessels. And at the end of the day, if such a rescue occurs, does somebody who utilizes their oil, the fuel, I mean, bunkers, they utilize maybe, they use their time, they use their other resources, including human resource, to assist another vessel that is in danger out there at sea? Do they just spend whatever they spend, or spend whatever resources they spend and not get anything in return? Is that a fair thing? No, it is not. And that is why at the end of the day, it was felt like the community, the international community felt that it was important to come up with some organized way of dealing with salvage incidents. And especially because, Major, if you can just move to the sixth slide. Yeah, as you can see, that is one of the, okay, those, this seventh slide, as you can see, there is a ship. I don't know if you can see it clearly. There is a ship, and there are containers that seem to be falling into the sea. So that ship seems to be in trouble. And just next to the ship, there is another red vessel, which seems to be a tug. And there's an aeroplane, whatever, helicopter. All of them are trying to conduct a salvage operation on this vessel. That is, I'm sure, maybe the people on board the vessel that need to be salved. Maybe it could even be possible that because this ship that is in trouble is listing dangerously, maybe the tug is there to assist in maybe pushing or supporting and all that. So it was quite necessary to come up with regulations and to come up with agreements on how to conduct such operations. I don't want to use salvage, now that we haven't yet gone far into it, or maybe I could still use salve. Yeah, it was agreed that there was need for laws, there was need for kind of plans and agreements on how to take care of a ship that is out there in distress. considering the treacherous waters that may be out there, the fact that such ships may be too far out, maybe in the high seas, not anywhere near close, not anywhere near maybe a safe haven and all that. So that is basically why salvage was felt to be very necessary in the maritime industry. Maybe if you could just go further. Yeah, so history, maybe just a brief history of how salvage came to be. It was actually an ancient rite and can actually be traced maybe more than 3,000 years ago. And that is ancient Greek laws and the Rhodian Maritime Code. Then it was based on a no cure, no pay principle. That is, if you fail to solve, maybe let's say ship A is out there at sea and ship A is in trouble, and yours is ship B. If ship B attempts to solve or to render assistance to save ship A, and it fails, and maybe ship A goes under, and the cargo is lost and all that, then there was the no cure, no pay principle. That is, if you're not able to solve that property, it doesn't matter how much resources you put in, you do not get to be paid a single cent for doing all that you do. However, if you succeed, then you get a reward. That is a generous reward. So that was what that was the principle then. So at the beginning of the 20th century, the law of salvage was codified by the Salvage Convention of 1910. Then thereafter, there was a move to amend the 1910 convention, which actually gained momentum with the surrounding of Amoko Cadiz and the 1978 that happened in 1978. And this Amoko Cadiz incident actually resulted in the Salvage Convention of 1989. Thereafter, there was, but okay, even with the existence of the Salvage Convention, there's been lots of common law and jurisprudence with regard to matters salvage that we'll see as we go on. And even the latest is the introduction of the environmental salvage. That is, if at all you even attempt to salve a ship that is in trouble out there, and you fail to really, you're not successful in the salvage, but you've made a proper contribution towards protection of the marine environment that will have been caused by the destruction from that ship, then as the laws developed, there was a provision for the saving of the environment. You'd also get a reward for that, which we'll see later as we move on with these with this class. So maybe the next slide. So the peculiar nature of the law of salvage. Actually, it is peculiar, as we discussed earlier, because one, we have the lonely treacherous seas out there. Then it is just to encourage others to assist. Because if indeed you'd go salve and wouldn't get any reward at the end of the day, then most people will just pass by and let the ship go under or remain in trouble instead of salving that which is on board. Then there's also a bit of discouraging piracy. So instead of maybe persons opting to go on board and maybe rob and kind of plunder a ship that is in trouble, then which is more or less piracy. It is they're given the option of actually salving that ship and claiming a reward from that ship, which is a legitimate way of getting income. That is another, that is part of the peculiar nature of the law of salvage. Let's move on, sir. So something else. So what is a salvage operation? So according to the 1989 International Convention on Salvage, a salvage operation means any act or activity undertaken to assist a vessel or any other property in danger in navigable waters or in any other waters whatsoever. So you can see the definition is very clear. That is, it's an act. You have to undertake an act to assist a vessel or any other property in danger in navigable waters or in any other waters whatsoever. So in that case, a salvo, upon the property being salved and brought to a place of safety, is actually entitled to recover salvage reward, not exceeding the value of the property salved, assessed at the date and place of the termination of salvage services. So, so once you salve, you get a reward, and of course, you cannot be getting a reward that is that is more than the vessel cost. It is actually a percentage of what the vessel cost and what the other property that maybe has been sold cost. So, and the reward that is given, it's not only because of the labor and services, but many things, many factors are taken into consideration. In some instances, when maybe a judge is making a decision on the reward that ought to be given, they'll take into consideration the many effort, the efforts that the effort that was put in by the salvo, maybe the degree of danger that was there. Maybe it was there was the possibility of an explosion, and the salvo worked so hard. Sorry, that's a new that's a new term in this class. A salvo is somebody who, or a party that goes to assist a vessel in trouble. The doer of the act of salving another vessel or any property that is subject to salvage. So the efforts that that person who is called a salvo puts in, the degree of danger in that circumstances, the value of the property that is salved, the value of the property employed. Maybe in this case, the salvo had to come with high-tech machinery to salve maybe the goods or the ship. So that also has to be taken into consideration. The time employed by this salvo, did he spend so much time in salving? Maybe 10 days that he could have used to sail and maybe conduct business elsewhere. He spent that time trying to salve the vessel. Then what was the risk? Was there a risk of peril, and how, what was the extent of that risk? So all that is taken into consideration when deciding on the amount of reward to give to a salvo. So any questions so far? Okay, maybe we can move to the next slide. So we've just defined what a salvage operation is. And the other, oh, sorry.
Yeah, I have a question. Yeah, I have a question, Malimu. Based on the description, back to the definition of salvage exercise, therefore, is it merely voluntary, or is it also a duty? Because if I am in a vessel and I see that the vessel next to me is in distress and that I can act to rescue it, do I have a duty as a sea user to contribute to such a salvage mission, or is it's purely voluntary? So that I want to say there's a legal duty underlaid somewhere. Thank you.
Thank you, Stephen. Actually, that is something that is an part of this topic, and we'll encounter it later. But maybe just before we get there, there is contractual salvage and there's the common law salvage. The contractual salvage has grown over time, but there's also the common law salvage. But if we are to put aside first the contractual salvage, you realize that under common law salvage, you're not supposed to have a duty, or you're not supposed to be obligated in any way to salve that vessel. If you have the obligations to do that, then it stops being a salvage per se. We'll get there as we go on. And we'll actually encounter the examples of maybe the crew of a ship, whether when their ship is in trouble and maybe it's going under, whether they're allowed to salve that ship and claim a salvage reward, or was it just a duty that they were supposed to do under contract. So we'll get there. So is that okay, Stephen?
Yes, thank you very much.
Yeah, we'll get there. So definition of salvage service. So the Admiralty Court has actually defined salvage service as a service which confers a benefit by saving or helping to save a recognized subject of salvage when in danger, from which it cannot be extricated unaided. So the rendering of such service ought to be voluntary, not attributable to a pre-existing obligation. We'll get there. So, but of note is like the words in bold, where we're saying that the recognized subject of salvage is in danger and it's not able to extricate itself unaided. If indeed it can, that ship can in some way maneuver and overcome the trouble it's in and may not really need the salvage assistance, then we cannot consider that really a salvage. So it is supposed to be in a situation where it's not in a position to extricate itself from it. Then that is considered a salvage. Let's go on, sir. So who is a salvo? I'm sorry, we used the term salvo before actually defining who a salvo is, but by use of case law, it's easier for us to understand who a salvo is. Like the Neptune defined a salvo as a person who, without any particular relation to a ship in distress, proffers useful service, not useful service, and gives it as a volunteer adventurer without any pre-existing covenant that connected him with the duty of employing himself for the preservation of that ship. To be useful service and a volunteer in this case. Then looking at the 1989 salvage convention, we are told that no payment is due under the provisions of this convention unless the services rendered exceed what can be reasonably considered as due performance of a contract entered into before danger arose. I'll read again. No payment is due under the provisions of this convention unless the services rendered exceed what can be reasonably considered as due performance of a contract entered into before danger arose. Just you can hold, we can hold on to that 1989 convention, the Article 17, as we discuss the circumstances of members of crew and whether or not they can be salvos. We can keep Article 17 in mind. So let's proceed. We'll encounter members of crew. So, and as Stephen, you raised the issue of, actually the issue you raised was whether there was if somebody with a duty of care towards that that ship, that is maybe a contractual duty, could also perform a salvage operation, or it was only a volunteer. We can look at it from the viewpoint of common law or contractual salvage. So actually salvage doesn't necessarily have to be hinged on contract, but as time has progressed, the majority of them are under contract, e.g. the Lloyd's open form. We'll see that at the end of the presentation. but we have the common law salvage, right? And still we have the contractual salvage, and which parties mostly employ the Lloyd's open form. But then salvage claim is not actually based on contract. Those salvage claims that are not based on contract are actually referred to as common law salvage claims. And you still get a reward even if there was no contract in place. So, however, with the development of the 1989 Salvage Convention, lots of strides have been in place to codify both the common law salvage and the contractual salvage, as we'll see as we go ahead with the topic. So, however, just like in Kenya, English common law still remains handy for us, even for salvage related issues. Common law still remains very much, it still affects the issues to do with salvage. Let's go on, sir. So salvage and contract. So generally, the common law salvage claims do not actually rest upon contract. But where property has been saved from sea perils and the claimants have effected the salvage or have contributed to the salvage, the law confers upon them the right to be paid a salvage reward out of the proceeds of the property which they have saved or helped to save. No doubt, the parties may by contract determine the amount to be paid, but the right to salvage is in no way dependent upon contract and may exist and frequently does exist in the absence of any express contract or of any circumstances to raise an implied contract. Therefore, it's possible to contract out of the provisions of the 1989 convention. It happens. So save for provisions on annulment or modification of contract and duty of salvo, the owner and master to prevent or minimize damage to the environment. So you can actually contract out of the provisions of the 1989 convention, but you cannot contract out of the environment related provisions of that convention. So let's go on. Yeah, there is a hand there, Mr. Omanga, Omwango, yes.
Just Arike is okay. So I have a question concerning what we just talked about. Is this contract on the reward, is it obligatory for it to happen post salvage, so that now you have agreed and then you say you have done this, then I will pay you this? Or are there persons who are in the business of salvaging and then maybe someone contracts them and then says, in case ABCD happens to my ship, then this is what you will do and this is the amount I agree to pay you?
Okay. Actually, as with time and the development in the laws, nowadays there's also insurance. There's the P&I clubs cover this bit also, but mostly for contracts. For contracts, most of the times you'll find that when a ship is in trouble, maybe I'll still refer to it as maybe ship A. When ship A is in trouble and salvos come, you'll find that most of the times they insist that a contract is in place, that is the Lloyd's open form, is in place before they undertake the salvage. Because, okay, we are humans. It's very possible that I undertake the salvage and challenges arise and there is the bit of you don't want to pay and all that, though in such instances you're still covered under common law. But I think for contracts, people, most parties prefer contract just because it firms up everything. It is clearer, and I think there is less contention as far as contracts are concerned. but I believe mostly it is at that point when a ship is in trouble that in most cases such contracts are entered into. Because, okay, sometimes a ship may even be in trouble for a period of time. And you'll find that in practice, in some instances, that is the time that the ship owners and the whatever, the salvos try to get into an agreement of sort, try to sign the Lloyd's open form just to ensure that there's a contract in place for the conduct of the salvage exercise. Major, do you want to add anything? Do you want to add anything to what I've said?
Well, just to add that, I mean, you started off on the basis of common law salvage and contractual salvage. Contractual salvage, of course, is something which is a product of the convention. It is a product of the industry coming together, and the whole idea here was for the ship owners and those who have interest in the ship, the cargo owners, the insurers, etc., being able to ascertain, on the one hand, their exposure, but also the salvors having a certainty of a reward in the event their efforts would prove not to be successful. I mean, under the convention salvage, it was a situation where if you are not successful, then you don't receive a penny, irrespective of whatever effort that you may have taken, the time that you may have used, and the equipment and the tools you may have used. On the corollary of that, on the flip side, if you are successful in salving either the cargo, the vessel, etc., then the value of that vessel and the value of whatever is salved would be the limit of the award that would be payable to you. Of course, there is a lot of adjustments that go into it and so on and so forth. So the whole purpose of creating this contractual salvage was to, in certain circumstances, to have a salvage exercise carried out by way of an agreement where you spell out that even in the event you're not successful, then this is the measure by which a reward will be calculated and be payable to the salvage company for the effort that they exercise. Of course, I'm sure as we go on, we look at the scopic clause and to see how that comes into play. But by and large, and Nafula is right, whenever we have a scenario, at least around the east coast of Africa, closer to home, where a vessel is in peril, has probably lost her engine, lost her rudder, she's drifting towards the reef, you'd find some of our agencies willing to offer them services to rescue them, and then we'll say, please sign the Lloyd's open form. Now, the Lloyd's open form, of course, then ties them down to providing or to paying a salvage reward for any efforts that may be made. And of course, when you talk about salvage, then you're talking about a big award once the efforts have been successful. Okay, I'm sure as we continue with our sessions this evening, things will become much more clearer. I hope we've answered your question.
Yes, you have. Thank you.
Okay. And again, just for those students who have logged in, please know that this is an extremely important topic from an exam point of view.
Okay. So thank you, Major.
Yeah.
So the other bit we'll look at is the consent of the owner. Do you need the consent of the owner before a salvage is conducted, or you don't? So under the 1910 convention, notwithstanding the express and reasonable prohibition on the part of the vessel to which the service were rendered, if they went ahead and took part in salvage operation, then such people or such salvos had no right to any remuneration. So that was what the 1910 convention provided for. So in short, as in, I haven't given you express consent to undertake the salvage, or maybe I have prohibited you from undertaking the salvage, and you still conduct that salvage, then you have no right to remuneration. That was under that 1910 convention. So what happened in the 1989 convention? Article 19 provides that services rendered notwithstanding the express and reasonable prohibition of the owner or master of the vessel or the owner of any other property in danger, which is not and has not been on board the vessel, shall not give rise to payment under this convention. Yes? Then you're saying, however, under specific circumstances, a salvage reward will actually have been earned, notwithstanding the prohibition of the master or owner, and the only qualification will have been if such award will have been inequitable. Thus, in the Auguste Legendre case, it was held that salvage is earned if the service, though not accepted or requested by owner, were rendered in such circumstances that they ought to have been accepted. A situation I can think about is maybe with regards to environmental salvage. Your maybe your oil tanker is in trouble, maybe around the Mamangina Drive, and or maybe the coral reefs that in Diani or a place like that. Your ship is in trouble, and we are certain as salvos, there's a high possibility that there could be a spill and it will affect the environment. We ask you, we tell you we want to come salve your vessel, sign the Lloyd's Open Form maybe. And as a ship owner or a master who's a representative of a ship owner, you decline our offer. If we insist and salve you, noting the possibility of the oil spill that will have occurred, then we are still entitled to a salvage reward. You cannot deny us a reward, yet we salve the environment. The next slide, please. So have you been taken through towage? Are you familiar with towage class?
No, they aren't.
Okay. So okay. Let me distinguish between salvage and towage contract. That, okay, sometimes there is confusion between those two. And we have case law that helps us in the distinction, because towage is like, okay, in brief, towage is what you see around Mamangina Drive sometimes. When you see the reddish, the KPA tags, maybe pushing or pulling or supporting a large vessel or directing the large vessel or any other vessel toward a certain place. That is called towage. It's just like the towing that is done on the vehicles on the road. That is simply towage. So what is the difference between the towage and salvage contracts? In the Princess Alice case, it was held that a towage service may be described as the employment of one vessel to expedite the voyage of another when nothing more is required than the accelerating of her progress. In short, for towage, there is no danger in place. If it's a purely towage contract, there is no danger in place. But as we have seen, for salvage, there has to be an element of danger for a salvage operation to be considered a salvage. Another a further explanation by them in the Minnehaha is the United Kingdom laid down the principle of law governing the duties of a tag in rendering towage. So for towage services, we have the tow and the tag. The tow is that ship that is being assisted or being pushed or pulled or taken towards by assistance of the other vessel that is called a tag. So we have a tow and a tag in the towage contract. Are we clear? Or I'm causing further confusion? Are we clear, class?
Yes.
Yes, on my side.
We are.
Okay, nice. So we can, they actually, the major distinction between towage and salvage is there being danger under salvage. So as part of the salvage operation, we may actually have a tag that assists that vessel by pulling it or pushing it just to maybe hoist it or help it maneuver out of the danger it is in. So there is that element that it's the word tow may be used for like the activity of pulling or pushing, but it's not a towage contract. It is actually if there is danger and in which that vessel cannot extricate itself from, then it is actually a salvage. Let's go on. So in the Homewood case, so the question was whether a towage contract can easily maybe convert into maybe a salvage. So we are told in this case that to constitute a salvage service by a tag under a contract to tow. An example, let's say, is as we've used a bigger vessel, just maybe a ship that is not able to maneuver properly within the Mamangina, whatever the how can I call it? The waters around Mamangina towards the port. The vessel is not able to maneuver properly, and there is need for a tag to assist in towing or maybe pushing, pulling, and all that. Certain elements are necessary for such a towage to become a salvage. So it may actually be a towage contract where the vessel is not able to, without any assistance, to get into port. It may just be maybe the KPA tags are employed and they are just under contract, they are pulling that vessel or pushing a vessel towards a berth. But then there are circumstances where it may actually transform into a salvage instead of a simple towage. And in the event that it kind of becomes a salvage, then it is subject to salvage, and a reward actually can actually be derived from it. So we're told that to constitute a salvage service by a tag and a contract to tow, two elements are necessary. One, that the tow is in danger by reason of circumstances which could not reasonably have been contemplated by the parties. So a danger, and this was not contemplated in their towage contract. Then that the risks are incurred or duties performed by the tag which could not reasonably be held to be within the scope of the contract. So maybe the plan was just for the contract was for the tag to tow the vessel towards port, but something extraordinary, a circumstances that is extraordinary has occurred. Maybe Hidayah came and it totally made the towage contract convert into salvage. Then in such a case, a reward can be derived. Let's go ahead, sir. Same as the Leon Bloom, it's just, and maybe, okay, even with the little time we have, I can just break down the Leon Bloom case. We are told that in some instances, okay, the question that arises is whether a towage contract can coexist with a salvage contract. And we are told that the two cannot actually coexist. One contract has to stop for another to start. So there will be a moment in time when the situation of danger arises, and at which moment the towage service ceases and the salvage service begins. Similarly, there can be a moment when the situation of danger finishes, and as such, the salvage service can finish and the towage service begins. So one has to suspend another for them to kind of to exist. So maybe Ako, oh, Mrs. Stephen.
Thank you, Malimu. I have a question here. At this moment of storage, the second party is intervening on the vessel. How about if the actions of the person doing the towing contribute to new risks that then necessitates a shift from a towage situation to a salvage situation? What happens in that instance?
In such a case, then there is, because for towage, there is a contract in place. And if I got you clear, you're saying that in the event that maybe the tag conducted itself in some way that put the vessel being towed in danger. Is that what you're talking about?
Indeed, madam.
Okay, in such a case, then there is maybe possibility of negligence. There is a possibility of breach of the contract that is in place that caused the danger. So, and actually earlier on in the notes we said that if at all it is the tag that puts the tow in that situation, then the tag cannot claim for a reward. And in fact, I believe the tow may actually go ahead and sue the tag for putting it in danger if at all there are any losses that occurred and all that. So does that explain?
Indeed. Thank you very much.
Thank you. Major, we can move to the next slide. So in short, what you've said is that there are many differences between towage and salvage, but the main difference is the danger bit. Okay, and for towage there's no need for danger, but salvage there has to be danger in place. Then for salvage, you realize it has to be there has to be kind of in the common law salvage, and even this under the 1989 convention, there has to be some element of success or maybe the environmental protection. That will that is also a difference which is not under the towage contract. Mwalimu, next. So what of pilotage? We know what pilotage is.
No, they haven't learned the legal aspects of pilotage yet.
Okay, thanks. So for pilotage, it's also good to differentiate between salvage and pilotage. Pilotage is actually when you're around Mamangina Drive and you see there's a ship at anchorage out there, and a KPA, the smaller boats from KPA, they're usually red and white. They ferry a pilot to take over the ship and bring it to port. That is what is called pilotage. And it's important to differentiate between pilotage and salvage. So in this case, let's just look at it literally, like maybe a KPA pilot, because boats are ship, because entry into the Kenyan port, there is compulsory pilotage. A foreign pilot cannot just take a ship into the Kenyan ports. There has to be a Kenyan or somebody contracted by the Port Authority to offer those services at the entry into the port. So in such a case, if such a pilot goes to take over bringing the ship into port, is there a circumstance where he can conduct a salvage now that it's him that is bringing in the ship to port? So we are told that in the Aldora, we are told that it was held that if the ship is in danger by reason of circumstances which could not reasonably have been contemplated by the parties when the pilot was engaged, and that the risks are incurred or duties performed which could not reasonably be regarded as being within the scope of such engagement, then a pilot can demand for a reward when he helps extricate the ship from such a situation. Next, I think the next slide is, it will actually clarify salvage further by bringing out the elements of salvage. So mostly we have 4 main elements of salvage, and we have maritime property, maritime property, which is, or property that is subject to salvage. We have the voluntary service bit, we have the danger bit, and we have the element of success. So very fast we'll run through the next slide, sir. The next slide is a maritime property. So this property salved must be categorized as maritime property. Let's go on. So we're told that salvage remuneration is not recoverable unless that which has been saved is recognized in law as being a property of salvage. And actually the 1989 convention defines the subject of salvage, and this includes the vessels, their apparel and stores, bunkers, cargo and freight, wrecked and derelict, including flotsam, jetsam, and lagan, and even wreck. So, and even if there was any other kind of cargo that is on board a ship, then it is also considered as a salvage, as subject to a salvage. Hence, when they are salved, then when a reward, when a decision on a reward is being made, then they also consider that as the property, as part of the property that was salved, and a percentage of the reward is gotten from it. Let's go on. And then definitions as per salvage convention, it defines vessels and other property as any ship or craft or any structure capable of navigation, and property is property not permanently and intentionally attached to the shoreline and includes freight at risk. Then so anything, actually almost anything that is out there at sea and is capable of navigation and it can be salved, it could easily be considered as a property subject to salvage, hence can be salved. Let's go on. Maybe a question that we can ask ourselves is, if I am to save a human being or members of a crew that are in danger, if I save them, are they properties of salvage or they are not? Maybe that's a question I should pose to the class. Do you think maybe a passenger in a passenger vessel or a member of crew, do you think they are subjects of salvage or they're not? Mr. Mwagandi?
Oh, sorry, but actually that was the exact same question I was raising my hand to ask. Sorry.
Nice. We will we'll decipher that as we go on. So just you'll tell me whether or not it has been answered as we proceed. Okay. Thank you, Major. You can see they just have definition. Okay. So Article 3 of the 1989 Convention, which is similar to actually Section 324 of the Kenyan Merchant Shipping Act. They both provide that the convention shall not apply to fixed or floating platforms or to mobile offshore drilling units when such platforms or units are on location engaged in exploration, exploitation, or production of seabed, mineral resources. So in short, we're saying, if at all we have a fixed platform, maybe in our EEZ, and we are doing oil exploration, so, and maybe the fixed fixed platform is having issues, that maybe it's collapsing or something like that. Does it mean that if we go and try to kind of assist in bringing it to safe, or assist in putting it upright or support, will that be considered as salvage or not? So in our law and in the convention, these fixed or floating platforms are not considered as subjects to salvage, but that is the general rule. The exception to the rule is if such fixed or floating platform is being transported maybe from the shore towards the place where it is supposed to be installed. In the course of that transportation, if that ship transporting this cargo gets into trouble, then this platform is considered a subject of salvage. So not when it is still being transported and when it is, and before it is installed. Let's go on, please. And another one, warships, of course, are not subject to salvage. And it's actually it's usually an exception in most of the conventions where it is said they're not applicable to warships or government ships not engaged in commercial services. And actually, that is what the Merchant Shipping Act has adopted as in its application. So, yes, Mr. Mwagandi, as you had said about life salvage, so salvage of persons, we are told that no remuneration is due from persons whose lives are saved, but nothing in this article shall affect the provisions of national law on the subject. So we are told that actually a salvo of human life, let's say in a situation where a vessel or a ship that is that has maybe millions, that has cargo worth millions, is in trouble, and on board we also have maybe members of crew. So if maybe several salvos come and attempt to salve that ship, then maybe two salvos or one salvo is busy righting the ship and protecting the cargo and all that. Then there is another salvo who is very busy trying to save the lives of the crew members. So does it mean that because human beings are not subjects of salvage, does it mean that this person who sacrificed and did not try to salve the ship for purposes of reward and instead went to save lives, does it mean that that person does not get any reward? So we are told that what usually happens is a salvo of human life who has taken part in the services rendered in the occasion of the accident, giving rise to salvage, is entitled to a fair share of the payment awarded to the salvo for salving the vessel or the other property or preventing, minimizing damage to the environment. Is that clear? Class, are you with me?
Yes, we are.
Yes, we are.
Sawa, let's go on. So, okay, yeah, Mr. Magandi, go ahead.
Yes, thank you for clarification. So I have a further question here, a follow-up question. So at the point, what happened at the point where no maritime property has actually been salvaged, but the people only, the salvos just took human life first and salvaged the people, but nothing that is considered maritime property was actually salvaged. So what criteria actually used to reimburse or to reward these people, or will it just not suffice?
Wow, nice one. Maybe Mercy, you also wanted to ask, then we can combine the two. There was
No, it's
another hand up.
actually the same question.
Wow, interesting. I don't know. I don't think I've thought about that, but I'll attempt. Um, in these circumstances, there is no there is no property that has been sold, right? So, and as per the 1989 convention, the only exception that is in place is in the event of environmental salvage. So my take, which I believe Major can further enunciate, is my take personally. I believe that in such a case, then we'll consider that as saving of lives at sea under UNCLOS. That is a duty under UNCLOS. I don't know, Major, have you thought about this?
Yes, I'm sorry. I'm not sure if I got the question entirely right, but am I correct to understand that the question is, what if we only save life but not the property? Is that the question?
Yeah, that was the question.
Well, there is no salvage award there. There is no value that one can put to life, unless, of course, if there was a scopic clause that had been invoked, or the circumstances under which uh, the salvage was undertaken, there was some prevention as far as environmental pollution may go. If there is no gain or no what is the word, success, then no salvage award shall be payable for just saving lives, because saving lives is not a concept that is that is under the salvage conventions, or salvage, there's a concept that is codified under the salvage convention or under common law salvage. Saving lives is but the fundamental rule or the fundamental law which is customary and embedded in the laws that relate to plying the seas. We've seen that obligation even under the law of the sea convention, if you will recall, where every flag state must ensure that its ships will respond to every vessel in distress to save lives.
Thank you, sir. Now, is it clear? Has your question been answered?
Yes, thank you. Then a last follow-up question. This is the last question. And on the issue of prevention of environmental pollution, so what parameters are used to sort of get the amount of reward to be given? Is there like a fixed reward? Or yes, that's my question basically. What parameters?
Thank you, Mr.
That is
Mogandi.
devoid of the issue of maritime property. Thank you.
Okay, thank you. You can again. You're very forward, but you're looking far ahead. We are gonna get there within no time. Sawa. Is it okay that we deal with it when we tackle environmental salvage?
That's fine. That's fine, Laura. I think we can
No
proceed.
problem. No problem.
And
That's
then
in order.
if there are any outstanding questions, please hold on to them. We are happy to revisit those questions at the end of the presentation.
Yeah, and we're almost there. The remaining slides are very brief. So we have other maritime properties that are that we spoke about, and I'm happy that Major has already given you the definition of the flotsam, jetsams, and lagan. So it's okay. I won't belabor that. So Major, kind of let us move on. So the first element of salvage was maritime property or stroke property that is subject to salvage, right? Then the second element is voluntary services. So one has to be a volunteer, but the definition of volunteer is not very clear under the salvage convention. It has not been defined. but it is but the definition of a salvo is a person who acts as a volunteer, meaning no pre-existing duty of law to act. And that is mostly, it also brings in the element of the common law salvage. Then the main exceptions are pre-existing contractual duty to act and maybe statutory duty to act. So if indeed what makes you not to be a volunteer, let's say maybe it's maybe the Kenya Navy, or let's say the county government of Mombasa had tags and tows, and it was engaging in salvage activity as part of its mandate. Then in such a case, that the county government cannot claim for a reward, because it's a statutory duty. Then in the case of a pre-existing contractual duty to act, and when there is this bit, I'm thinking about members of crew that are on board a ship. So when they have the contractual duty to act, that is to protect the ship and do all that they can to save the ship, then even for them, there's a limitation. But let's go on. We'll see which limitation is in place. Let's go on, sir. So payment can only be made in salvage if services rendered exceed what can reasonably be considered as due performance of a contract entered into before the danger. So that is, it has to be outside the scope of pre-existing contract, something not envisaged by the parties when they contracted, right? So think of a member of a crew member, as just have that in mind as you go on with this. Then no payment is due under the provisions of this convention unless the services rendered exceed what can be reasonably considered as due performance of a contract entered into before the danger arose. If it was your duty to make sure that the ship does not run aground, and you do your best and you actually ensure that that ship does not run aground, if it was part of your duty, then that is not, you cannot claim salvage in such a case. But let's go on. There is an exception to that general rule. So we already talked about the pilotage contract and the towage contract and the possibility of it turning into salvage. So let's go on. That has already been covered. We can look at the next slide. So other statutory, people obligated under statutory instruments, maybe to assist, like fire brigade, port authorities, Royal Navy, Coast Guard, if they render their assistance, then they're not supposed to be claiming a salvage reward. However, this is not an absolute rule, and gauging different circumstances that may actually exist at the time, the court may actually decide otherwise. But the general rule is people with statutory duty are not supposed to claim for a reward. Let's go on. So the bit that was asked, and Mwagandi, we get to answer your question. So when it comes to ship's crew, we are told that the Salvage Act must be voluntary. It must not be performed as part of contractual duty or self-preservation. Therefore, as we can look at the San Dimitrio case that actually made it very clear, and we're told that the San Dimitrio had been a ship in the Second World War, and it was built in 1938. So while out there, it was damaged by enemy action in mid-Atlantic, and members of crew actually abandoned her. But later, they reboarded and successfully brought it into the harbor. Her master, that is Captain West, believed that the fire, actually it was on fire, that the fire could set off the aviation fuel at any moment, and he gave the order to abandon ship. 16 of the crew drifted off in their lifeboats, but ended up near the San Dimitrio, where they boarded and repaired it and managed to sail the tanker across the rest of the Atlantic, braving bad weather and U-boats. After 7 days, the San Dimitrio reached waters of Ireland, from where they were escorted to the mouth of that. So despite the damage and fire, only 200 tons of San Dimitrio were highly volatile and had been lost. So the court held that they rightfully claimed and were awarded a salvage reward. What are we saying? We're saying that if you're members of a crew, you have a duty to protect the ship. You have a duty to, maybe the engineers are there, the deck officers are there. You have a duty to kind of fulfill your part of the contract. But in the event that the ship is in trouble and the master actually gives the order for members to abandon the ship, then it means that is when you abandon the ship, it means the contract at that point has been kind of held in abeyance, right? So in such a case, when they abandoned, their duty to save the ship and protect the ship had already had kind of been set aside, because they abandoned the ship. They're not really obligated to again try saving the ship. But these few people, members of crew, who again boarded the ship later and actually salved the property and the ship, were actually they were actually awarded a salvage reward. So not for members of crew, there's a contract in place to, or a duty to serve the ship and to protect the ship and all that. But if an abandonment order has been given by the master, then the contract is kind of held in abeyance. And if parties still go back on board and salve that ship, then you can actually claim for a salvage reward. But this is just case law, and I think it depends with the circumstances and all that. As you can see, for this San Dimitrio, so much was done by these, I think, 20 members of crew that went back. Mwagandi, has your question been answered? I hope so. Next slide, please. So we've looked at the property of salvage or maritime property. That is the first element. Second element, what was the second element we've looked at, class?
Voluntary services.
Perfect. So the third element you're looking at is success. So in the absence of success or a contribution to success, the person rendering services, however great his efforts and expenses may be, is not entitled to a salvage reward. So there has to be either a success or a contribution to success. So it's very possible two salvos went ahead to try salve a ship. Maybe one was actually successful in doing it. Or maybe the first ship, even a better example is, maybe the first ship tried, was not successful, but at least in some way it extricated the other ship from the grave danger it was in. Then ship number two, the second ship that had salvos, the second one, actually finished the job and got a reward. Does it mean the first ship that actually extricated in some way the ship in trouble, does it mean the salvos on that one do not have no right to any reward, or they can still get a reward? In such a case, they contributed to the success. And if indeed they did contribute, then they have a right to reward. So this follows the no cure, no pay principle, as principle that has been the focal point of salvage and arises as a natural consequences of the reward being payable out of the property being salved. It actually goes ahead actually to, I think this actually supports the explanation by Major concerning saving of human beings. There has to be property salved unless it's environmental salvage. So let's go on. So a case that you can look at your own time. It's the Melanie versus the Sanov. It's all about the success. We can go on, sir. And you realize we're told it's not just a contribution to success. It has to be significant. It has to be meritorious contribution to such success. Then there is the Tojomaru, that is a 1972 case. We're told that the first distinctive feature is that the person rendering salvage service is not entitled to any remuneration unless he sells the property in whole or in part. This is what is meant by success in salvage cases. So in whole or in part, so long as there was saving something, then that is success. Let's go on. So elements of success, they're implied in Article 12 and 13. So, and in this, we can look at the conditions for reward. So salvage operations which have had a useful result give rise to a reward. That is useful result, mark, meritorious contribution, right? So except as otherwise provided, no payment is due under this convention if the salvage operations have had no useful results. If you attempted to salve another vessel, spent your resources and all that, but you got no useful result, then you cannot claim for a salvage reward, which is the no cure, no pay principle. We are even told that this chapter shall apply notwithstanding that the salved vessel and the vessel undertaking the salvage operations belong to the same owner. It still applies. Then Article 13, we have just like, I think there was a question on the same. What is the criteria for fixing the reward? So the rewards exclusive of any interest is recoverable, and recoverable legal costs that may be payable thereon shall not exceed the salved value of the vessel and other property. Surely the property may not be costing 1 billion and you're requesting for a reward of 2 billion. It wouldn't make sense. So Article 14 provides for special compensation and makes it possible to have some form of reward even without having useful results. Previously, you've had us referring to environmental salvage. So that is all in Article 14. You've not salved any property. In fact, maybe everything has been lost, but maybe there was a possibility of a spill that you helped not occur. Then you can come under environmental salvage and you can actually get a reward. Let us see what this is all about. Can you move, sir? So this success does not have to be attributable to only one salvo. Just as we said, all those salvos who have contributed to ultimate success will have a valid claim proportionately to what they contributed to the final success. Then in the Camille, we're told that a mere attempt to save the vessel and the cargo, however meritorious or well-intentioned that attempt may be, or whatever degree of risk or danger may have been incurred, cannot be considered as furnishing any title to salvage reward if it does not contribute to the ultimate successful salvage of the property in peril. Let's go on, sir. Then the fourth element, we've talked about 3 elements so far. The fourth element is danger. And we are told to make a successful salvage claim, the property being salved must have been in danger. So although the degree of danger is relevant to the amount of salvage award, for a claim to be successful, it is not necessary for there to be a high degree of danger. The element of danger in itself is sufficient. So the danger must exist where sensible concern of danger is enough. The scope of the danger can be from the risk of total loss to the risk of damage, I mean. So long as there was danger, the degree may vary, but if there was danger in this situation and a salvage was conducted, then it may suffice. But remember, we are told the ship is in such danger that it cannot extricate itself from. Let's note that. Let's go on, sir. So in these cases, we are told that there must be an element of danger from which the property has been saved. Then we are told the danger does not have to actually be immediate. A ship may actually be like a ship that maybe has lost its engine or it's going under. It may take a while for it to totally be destroyed. So the danger may not actually be immediate. Maybe it has started taking water today. It may not be immediate, but there is an imminent danger that can be there's the bit of the imminent danger being foreseen. If that is the situation, then it's also considered as danger, and it does suffice. Then let's go on, sir. So we have a case law on danger that you can look at your own time. It will be part of the note, where it's like for the national defender, we are told that the danger does not have to be immediate. But if it's danger already in place, then salvage can be considered. Let's go on, sir. So what of future and contingent danger? We have the Hamtum. It's a 1999 case. So it was affirmed in recent years that even if the wind temporarily stops the swings of the vessel, there might be sensibly future apprehension of danger. Wow. Okay, let's go on. So there is just further discussion on the degree of danger, and an example is in the Phantom. We are told it's not necessary that there should be an absolute danger in order to constitute a salvage service. It is sufficient if there is a state of difficulty and reasonable apprehension. So that works. Let's go on, sir. So far, we've looked at the 4 elements of salvage. We've talked about the salvage property. We've talked about the volunteer, that is the salvo. Then we've talked about the bit of success. Then we've talked about danger. Those are the 4 main elements of salvage. And now we can look at a reward. A question arose as to how a reward is determined. And under Article 13, for the criteria for fixing the reward, we are told that certain elements are taken into account, and the court considers stuff like the salvage value of the vessel and other property, the skills and efforts of the salvos in preventing or minimizing the damage to the environment, the measure of success obtained by the salvo, nature and degree of danger, the skill and effort of the salvo in salving the vessel. Let's go on, sir. Time used and expenses and losses incurred, the risk of liability and other risks run by the salvo. We have the kind of equipment that was employed, the promptness of the service rendered. Maybe if there were delays, it would have been worse. The availability and use of vessels or other equipment intended for salvage operation, and the state of readiness and efficiency of salvo's equipment. It's also part of what is considered when constituting the salvage reward. So salvo, upon the property being salved and brought to a place of safety, is entitled to recover salvage reward, not exceeding the value of the property salved, assessed at the date and place of the termination of salvage service. The reward shall be made by all the property interests in proportion to their respective salved values. So it's not just the ship owner that is has to pay pay the reward. It could be the ship owner and together with everybody who had cargo that was salved. So everybody contributes towards that salvage reward. And that is why nowadays, even for shippers, there's usually an additional fee that is paid for towards insurance. And yeah, it could contribute to this. Let's go on. Now, the other bit is environmental salvage. It was not in the 1910 convention, but the 1989 convention deemed it necessary to bring in environmental salvage. So we are told that if the salvo carried out salvage operations in respect of a vessel which by itself or its cargo threatened damage to the environment and has actually failed to earn a reward under Article 13, this is the normal salvage reward for successfully salving property. If this person undertook salvage operations but did not actually salve the property but ended up saving the environment, so in this case, at least equivalent to the special compensation accessible in accordance with this article, he shall be entitled to special compensation from the owner of that vessel equivalent to his expenses. So there shall be some special compensation just for saving the environment, and this has to be it has to be from the owner of that vessel equivalent to his expenses, the out-of-pocket expenses of this person who conducted environmental salvage. Let's move on, sir. So damage to the environment means substantial physical damage to human health or to marine life or resources in coastal or inland waters or areas adjacent thereto caused by pollution, contamination, fire explosion, or similar major incidents. So all these are considered damage to the environment. Let's go on. So what is there an exception to the success rule? I'm sure by now you already know whether or not there is an exception to this rule. And this is still under Article 14, where we're told this is a salvo who has carried out salvage operation in respect of a vessel which by itself or cargo threatens damage to the environment. And he has actually failed to earn a reward under Article 13. That is the traditional salvage reward. In this case, he'll be entitled to special compensation. So we are told the total special compensation accessible under this section shall be paid only if and to the extent that such compensation is greater than any reward recoverable under Article 13. Let's go on. So duty of a salvo, that is the other bit. Does the salvo have any duties? And if there are, which are these duties? One, it's to carry out the salvage operation with due care, to exercise due care to prevent or minimize damage to the environment. If need be, depending on the circumstances, to seek assistance from other salvos. So if a salvo tries to conduct salvage operations and maybe midway, they realize that they don't have the proper equipment to kind of conduct the salvage to completion, then they have a duty to seek assistance from other salvos. Then to accept intervention of other salvos when reasonably requested to do so. In Tojomaru, a driver negligently fired a bolt from a cox gun into a tank which had not been gas-freed, hence resulting in an explosion. It was held that the general English law of negligence was applicable and salvos liable in damages, and the salvos are liable in damages for negligence. The court, however, observed that standard of care could vary in different circumstances, considering the difficult circumstances of a salvo's work. Then we also have the LLMC convention that allows a salvo to limit his liability, and this works. Yes, so we have the limitation of liability in the LLMC convention, which is also actually the Merchant Shipping Act has also adopted the LLMC convention, and this is a convention on the limitation of liability, and a salvo can limit his liability on that. Next, sir. So what is is there only a duty for the salvo, or the master and owner also have duties? So the master or owner has a duty to cooperate fully with salvo during operations, to exercise due care in preventing damage to the environment. You note the environment is a big thing, Then to accept delivery of the vessel or property when it is brought to a place of safety when reasonably required to. So yeah, just to avoid abandonment of such vessels. So when a salvo kind of like utilizes so much of his resources to bring as property, a salved property, to a place of safety, and then the master or owner is obligated to accept this property. But in some instances, you'll realize that they actually, if at all, maybe the master or owner, okay, not the master, if at all the owner feels like maybe it is, maybe the vessel has been, maybe it's totally destroyed and may not fetch much, and maybe there is so much to be paid still to the salvo for his services. In some instances, you'll find such vessel being abandoned. So in such case, what can happen? Not part of the salvage circumstances. What can happen in such cases? Like in the convention, just like in the Merchant Shipping Act, there's a provision on lien, and in such a situation, this a ship is part of maritime property, and it can actually that can actually be exercised, and the rights of a salvo is actually also really paramount. It's actually it's up there in the list of those the people to be paid in the event that maybe a ship is sold and all that. So that is just not necessarily part of our notes today, but something to think of and just something to note. So when you get out there and you're in practice, God willing, you may encounter this and yeah, think about it. Then we go on. Yeah, we're almost at the end. So we're talking about contractual salvage. You realize we've discussed both contractual salvage, and we've discussed about lots of common law salvage, and we note that they both work. Though in the recent past, most people are going for the contractual salvage because, as we said, it is more structured. It's firm. It's robust. So the authority to contract, as per Article 6.1 of the Convention, it is possible to contract out of the provisions of the Salvage Convention, so long as the same does not affect the application of Article 7, that is on environment. So you can contract out of the provisions of the salvage, as you realize there is freedom of contract, but still you cannot avoid the bit on environmental salvage. You cannot contract out of that. Then a master has power to conclude such contract on behalf of the owner. Then a salvage contract such as LOF, it's called Lloyd's Open Form, is usually made on behalf of ship owner, cargo owner, and owners of all property on board. So it's not just the ship owner that LOF is made in respect of. It's a ship owner and all the cargo owners or any other property on board that ship. So each and every owner is liable for the ultimate salvage award in proportion to the value of his property. So when a reward is being given, or like everyone with property that has been salved, there's a percentage and you pay in proportionate to the value of the property that you have. Then while the master has the authority to contract on behalf of ship owner, does he also have the authority to contract on behalf of the cargo owners? Good question. Let us see. Let's go on, sir. So before 1989 convention, in a bid to resolve this problem, English law adopted the doctrine of agency of necessity. So criteria for this doctrine to be satisfied were: it was necessary to take the salvage assistance, it was not reasonably practicable to communicate with cargo owners or obtain their instructions, the master or ship owner acted bona fide in the interests of the cargo, then it was reasonable for the master or ship owners to enter into the particular contract. So this is the criteria in this case, in the agency of necessity. So this doctrine became increasingly challenged with development in communication. You know, long ago, the communication was not as good as it is currently. So that is why the agency of necessity was being used. And this doctrine was being used then because of communication wasn't really good. And the agent could get into a contract on behalf of the cargo owners because of all the four that we have mentioned. But it became increasingly challenged. And in the Chocosta, the challenge was, however, the fact that even with communication, there was a possibility of one of the many cargo owners refusing to agree to the contract. So this, as much as this doctrine was being challenged, because people felt like with communication, it was now easier to reach the cargo owners to agree to the LOF contract. But then the other side, the flip side was that there could have been ease of communication, but the problem is some of the cargo owners will actually refuse to be part of that agreement. So where does this leave where does this leave the parties involved at? So that's why the agency of necessity, that doctrine actually still stood. Let's go on, sir. So in the Amoko Cadiz, the master refused to agree to the LOF until consultation with owners in New York. So this may not have significantly deterred the tug from making fast and best effort to tow the ship clear of the rocks, but in a later review of the circumstances of the casualty raised, it was an alarm was raised that there could have been potential delay in agreeing on salvage contract for a ship that risks causing substantial damage to the environment. Now put yourselves in the master's shoes, where in this case, the ship is in trouble, but you have to seek for approval from your owner before entering into a Lloyd's open form kind of contract to be salved. It is not said that in this Amoko Cadiz, indeed, this was significantly what led to the maritime incident, but it was observed that it is bad practice, because sometimes there may be such great urgency that the master just enters into an agreement under the Lloyd's open form on behalf of the owner, and this actually works. So Article 6.2 of the convention resolved this problem. It provides that the master shall have the authority, not shall, the authority to conclude contract for salvage operations on behalf of the owner of the vessel. The master or the owner of the vessel shall have the authority to conclude such contracts on behalf of the owner of the property on board the vessel. So this master can actually enter into the Lloyd's open form on behalf of the owner and on behalf of the people with property on board the vessel. So this was actually settled. Let's go on. So we've mentioned this time and again. It's a major advancement in the salvage, in the maritime industry and in issues salvage, and it is the Lloyd's open form. So question is, what is Copic? We'll encounter that. So Lloyd's open form is the contract form between the salvor and owner of the ship. You note that this is that contract that a master can enter into on behalf of the ship owner and on behalf of the cargo owners, right? So In that Lloyd's open form, there's usually a clause called the scopic clause. And this scopic clause is meant to be an alternative option for the contracting parties to agree to replace the salvage convention, Article 14, when signing a salvage contract, LOF, that is Lloyd's open form, right? Let's go and we'll explain. So Lloyd's open form provides a regime for determining the amount of remuneration to be awarded to salvors for their services in saving property at sea and minimizing or preventing damage to the environment. The scopic is not part of every Lloyd's open form, that is salvage contract. It is an optional addendum which is only included into a Lloyd's open form if the parties specifically record on the contract that scopic is incorporated. Let's go on and see. So what is the history of scopic? So to encourage salvo to go to the assistance of ships in distress, the 1989 Salvage Convention ameliorated the harshness of this age-old no cure, no pay principle. Sorry, principle, the spelling has an issue. By introducing in Article 14 a new concept, special compensation. You remember Article 14 of the 1989 Convention is on environmental salvage. And this is what was introduced in Article 14. Article 14 was well-intentioned, but in practice, it turned out to be cumbersome, contentious, and expensive to operate, and had the wholly unintended consequence of discouraging salvos from attending casualties where there was the threat of environmental damage. Traditional salvage awards were always paid by property underwriters, that is ship and cargo, but under Article 14, it was the liability insurers, that is the P&I clubs, who are to pay compensation. They were also unhappy with the new provision, which involved them in salvage for the first time. So both salvo and the ship owners had some concerns with Article 14. Let's go on. So ship owners and P&I clubs were concerned that salvo could unnecessarily prolong the salvage operations to claim more expenses under special compensation. That is Article 14, sorry. Also, the hull underwriters might delay the decision to declare the vessel as total constructive loss, as they would have nothing to lose by delaying their decision. Then in addition, rather than encouraging environmental salvos, it limited the amount that such salvos could be paid to mere out-of-pocket expenses with no allowance for any profit margin. So that is why they did not like Article 14. Let's go on. So in response to the problem, the shipping industry worked cooperatively to devise the scopic clause. You remember the scopic clause is a clause in the Lloyd's open form. Lloyd's open form is the contract between the salvos and the ship owner, and in which case the master is authorized under the convention to sign on behalf of the ship owner. Let's go on. So the special compensation sorry, sir, just still there. So the special compensation P&I club clause, which was specifically designed to replace and have the same effect as Article 14, but avoid the legal problems that the assessment of special compensation and Article 14 caused. So scopic is a very large clause, one made up of 16 sub-clauses, 3 appendices, and 2 code of conduct. Just go on, sir. So once that scopic clause is invoked, it substitutes the Article 14. So it solved 2 concerns for salvos. So once invoked, it was applicable in all geographical locations and was not limited to coastal and inland sea. It was applicable even if there was no threat to the environment. And second, scopic clause required security of $2 million, which made the salvo sure of the payments. Let's go on. You can go on, sir. So we have 10 essential elements of the scoping clause, which I'll just run through very fast because we are actually at the tail end anyway. So the element is designed to be an addendum to the Lloyd's open form. When incorporated in the contract, it replaces Article 14 of the Salvage Convention. Even when Scopic is incorporated into the contract, its remuneration provision will not begin to bite until the clause is specifically invoked by the salvo in writing. So once Scopic has been invoked, the ship owner must provide security in the sum of $3 million. Then once Scopic has been invoked, Scopic remuneration will be assessed in accordance with a tariff for main tags, equipment reasonably engaged. There's a percentage that is in place. Let's go on, sir. Then the assessments of the assessed Scopic remuneration is to be paid by the ship owner or his P&I club to the extent that it exceeds the traditional salvage award made under Article 13. Then more or less for the remainder of the notes, actually just the remaining elements of Scopic, you can always kind of like look at your notes and oops. Oh, for the remainder, sorry, I kind of accidentally switched off the microphone. So I'm saying for the remainder elements of Scopic, you can just familiarize with the notes if that interests you. But so far from the lesson, we note that in salvage, we have 4 main elements. I don't know if anyone can list the elements so far. I'm sorry, I know it has been a long class, but do you at the very least, remember the elements?
Yes. Maritime property, voluntary services, success, and element of danger.
Thank you. Anything else? Anyone? Any other take home that anyone has gotten from the lesson of today? Any take home? Okay, then. Any question?
A take home which also could count as a question, especially when we were talking about Article 14 in terms of a reward where there has been like, we were talking about success, then the reward is where there was salvage in terms of environmental protection. I think you read something that the reward will only be if the assessment is to be that it would be higher or at least the same, if I got it right, as it would be in Article 13, the normal reward. I was wondering what happens if it's lower than what it would have been under Article 13. Does it then mean that they're not entitled to any special compensation?
Thank you. Any other question? Is there any other question, or was the lesson clear, or you still need to refer to the notes after this?
Maybe just a clarification, yeah, Maritime. This, the deposit of the $2 million, and I think you said in one of the slides that after the salvage they are paid $3 million. Is the $3 million the minimum amount that they are paid? So that is why you have to put the $2 million deposit, or does it depend on the amount of salvage to be done?
Just a sec. Let me just look at the note. We're told that Once COPIC has been invoked, the ship owner must provide security in the sum of 3 million. I think this is a security. I think the two, it's just it's a confusion, but it's $3 million. Then the earlier question, what was the earlier question on? The Article 14.
Yes, Article 14.
Just remind me again.
So there was a part when we were discussing Article 14. You say that the salvo will be entitled to an award if whatever award the assessment is greater than, if I heard correctly, than what he would have been entitled to under Article 13. And so I was wondering, because of that caveat, does it mean that if then the reward would be much lower than what they would be entitled to under Article 13, does it then mean that they will not get anything?
I'll attempt to answer that, but Major can also assist. So what Article 14 actually says is, if the salvo has carried out salvage operations in respect of a vessel which by itself or its cargo threatened damage to the environment and has failed to earn a reward under Article 13, there is no reward under Article 13, at least that reward that is equivalent to the special compensation accessible in accordance with this article, that is with Article 14, he shall be entitled to special compensation from the owner of the vessel equivalent to his expenses. That is only the out of pocket. So he'll only get out of pockets. So one, he failed to earn a reward under Article 13. That is the normal salvage, traditional salvage reward. And to earn a reward that was actually equivalent to the special compensation that is accessible in accordance with this article. If he failed there, then all he gets is out of pocket expenses from the owner. So that is where we stand.
Yeah, just if you'll allow me to jump in there. Essentially, if you're going to look at what Article 14 provides, is where a salvage operation is unsuccessful, okay? Where you have salvors who have come on site, they've exerted effort, they've taken their time, and where they've made attempts to salvage the ship or its cargo, or those that is categorized as salvageable, as the object of the salvage, and they've been unsuccessful, but have either directly, but have directly contributed to an environmental protection or prevent degradation or pollution of the environment by their effort, then under 14 or under Article 14, there would nevertheless be, they would nevertheless earn an award calculated in accordance with Article 14 for that effort which has contributed to the protection of the environment. Are we together?
Yes, we are. I think my question came from the discussion when we were discussing Article 14, Sub-Article 4, where it says the total special compensation under this article shall be paid only if and to the extent that such compensation is greater than any reward recoverable by the salvo under Article 13. This only if, now if we skip everything.
So it's providing for a tier system, okay? So where there is a compensation payable under 13 and the one calculated under 14 is greater than, it's only in that circumstances where 14.4 will apply.
Okay, thank you.
Okay. It's 8 o'clock. Laura?
Yeah, I'm done. We're done with the presentation. Thank you, Major.
Okay. Thank you very much. Thank you very much. I propose that we stop here. Clearly, you've taken a lot of time to prepare the presentations, to prepare today's lectures, um, and to ensure that the students, in the limited time that we had with you, get an overview of the subject matter. Salvage, again, as any maritime practitioner will say, is a subject that takes a lifetime to learn, with all its different facets that apply to salvage and all the other criteria that apply to a salvage situation. So I remain grateful for you once again to accepting to teach the class today. I'll invite one of the students to please give a short word of thanks. Masi Omango.
So on behalf of all of us, thank you. Thank you very much. For me personally, and I know I speak for everyone here also, I think I have learned a lot about this topic, which prior to this discussion, I really did not know anything about. So once again, thank you. And hopefully we get an opportunity to learn from you once again. And if I could just, no, actually that is all. Thank you.
Very well. Thank you so much, Masi. Thank you, class. I wish you all a very good night. And I will see you soon during our next session. Laura, I wish you a good night. Thank you once again.
Thank you too for the opportunity.
Thank you, Maritime.
Good evening.
Thank you.